Good morning. Good morning. Thanks to all of you who have chosen to attend this panel discussion, and many thanks to ACS for agreeing to put this discussion together. The issues that we'll be talking about this morning, gun politics, policy, and most importantly, constitutional law on the area of firearms policy, should provoke a very interesting discussion this morning, I hope. But I also think it's great ACS has hosted this panel because I think they represent very important questions as well that implicate fundamental issues of public safety. So I think you're in for what I hope will be a terrific discussion. My name is Adam Skaggs, and I am a proud member of the New York Lawyer Chapter of ACS. And for all the law students in the audience today, I would say that your ACS experience won't end when you graduate. And wherever you settle, wherever you begin your practice, find and join or found your own lawyer chapter. It's terrific to continue the important work of ACS. In addition to being a member of the New York Lawyer Chapter, I am also senior counsel at Everytown for Gun Safety. Everytown is the nation's largest gun violence prevention organization. We have over 3 million members, including a grassroots movement of volunteer moms in all 50 states across the country, a coalition of Republican, Democrat, and independent mayors, and a network of more than 1,000 survivors of gun violence, all working for what we believe are important common sense laws that will help to keep our communities safe. As I said, we've got a terrific panel this morning. I'm very excited about the discussion that we're going to embark on. I've been asked to share a couple of housekeeping details before I get started. First, if everyone could turn off cell phones, this is being recorded and we don't want any unexpected interruptions. We'll have 90 minutes for the discussion. We're going to aim to reserve about 20 or hopefully about 30 minutes for Q&A from the audience, and I'd ask if you just hold your questions until we get to that part of the discussion, and then we'll provide mics so that your questions can be recorded. Finally, this session has been approved for CLE credits, so for those interested in that, you can either look at the CLE handout that came in your bag, or see the CLE table just directly outside the room. So with that, let's get started. I wanted to share a couple of sort of introductory thoughts before we turn to the panelists. And the panelists, it's a terrific group. There are detailed bios in the convention brochure, so you can get some further information. I'm not going to spend a lot of time introducing them, but quickly, immediately to my left is Christine Van Aken, who is Chief of Appellate Litigation and Deputy City Attorney in the San Francisco City Attorney's Office. Christine has either been lead counsel or co-counsel in a number of really important Second Amendment cases, including an important case just decided yesterday by the Ninth Circuit sitting en banc, having to do with concealed carry, as well as cases involving things like safe storage requirements, high-capacity magazines. I could probably go on, but I won't. To Christine's left is Deepak Gupta, who is the founding principal at Gupta Wessler here in Washington, and in the interest of full disclosure, I should say, has been counsel for Everytown on several Second Amendment briefs that we filed in recent months. To Deepak's left is Alan Gura, founding principal of Gura and Pozeski, and I think it would be accurate to say the architect, I don't know if you like that term, but of the landmark Supreme Court decision in 2008, District of Columbia versus Heller, which will, you won't be surprised, be something that we'll come back to today several times. And finally, on the far left is Adam Winkler, professor of law at the UCLA School of Law.
I've been called worse.
One of the nation's leading constitutional scholars and an expert on Second Amendment law. So you're in for a real treat with this distinguished panel this morning. Again, just a couple of introductory thoughts. The nation's going through a period of profound change when it comes to gun politics and gun policy, to say nothing of the evolving constitutional law in the area of the Second Amendment. I think there's every reason to believe that these issues will play an important role in the ongoing national conversation around the 2016 election. And there have been significant changes. You know, a generation ago, gun policy was seen as sort of the untouchable third rail of politics, at least for the Democratic Party. And yet what we've just seen during the primary season is that gun policy has been a key issue in the just concluded, or perhaps soon to be concluded, Democratic primary, I hope. On policy, too, we've seen significant change in recent years. While after the Sandy Hook shooting, Congress failed to take any meaningful action to address gun violence, since early 2013, we've seen a huge amount of activity in the states. Since that time, we've seen important laws addressing gun possession and use by dangerous domestic abusers passed in 21 states. Those have almost uniformly been passed by broad bipartisan majorities. They've been signed in blue states, red states, and purple states, including laws, important domestic violence laws that have been signed by conservative governors like Nikki Haley, Scott Walker, Bobby Jindal, just to name a few. So there's been tremendous movement on that. We've seen states acting to close loopholes in the federal background check law. We now have 18 states that require comprehensive background checks, and this fall, voters in Maine and Nevada will have an opportunity to make those states number 19 and 20 in terms of closing this really important loophole in federal law. So a tremendous amount of change, both in terms of politics and policy. There are also, at the same time these changes have been happening, has been a tremendous volume of constitutional litigation around the Second Amendment, testing the types of regulations that are or are not permissible under the Second Amendment, and that really is going to be the focus of our conversation today. As I alluded to a moment ago, any discussion of Second Amendment jurisprudence, I think, starts with District of Columbia versus Heller, in which the Supreme Court, for the first time, announced that the Second Amendment protected an individual right, unconnected to service in any organized militia, to use handguns for self-defense in the home. And while it is certainly true, I think, that Heller represented a major turning point in Second Amendment law, I think it's also true that Heller left as many or perhaps more questions than it provided answers. And those questions, which we'll talk about today, provide a fascinating glimpse at how constitutional law evolves in American law. But I would also just take a moment to say, particularly for the law students in the audience, that these questions also present really interesting opportunities for scholarship. For those of you thinking about student notes or thinking about organizing symposia at your law schools, this is an area of really intense and fascinating research and scholarship. And for those thinking about careers in the legal academy, if you're looking for a new and exciting area of constitutional law to focus on, I'll just plug the Second Amendment as one to look at. So the panelists will really dig into some of these questions, but just to give a sense of the breadth, Heller left open a series of substantive questions, notably questions regarding the extent and the manner in which the Second Amendment applies outside the home. Heller, of course, dealt with the law regulating gun possession and use in the home. Guns in public is an area that the lower courts are grappling with. Notably yesterday, the Ninth Circuit, I suggested, issued a very important question, and I'm sure we'll talk about that. In addition to substantive questions, it left open a series of procedural questions. So questions like whether strict or intermediate scrutiny is appropriate. That question in particular is currently pending before en banc panels of both the Fourth and the Sixth Circuit in cases that implicate some substantive issues as well. So there's really just a host of different substantive and procedural questions that make this such a fascinating area. And with that as sort of an introduction, I'd like to turn first, Christine, to you and ask whether you would provide us sort of an overview of what you see as some of the most important or most interesting questions that are currently being litigated, and to the extent you're willing to make any predictions, where you see the case law going on those issues.
Sure. Well, thank you so much for having me today. I'm really glad to be here. I, too, am a proud member of the Bay Area lawyer chapter of ACS and have been for a while. So I echo Adam's encouragement that you get involved with your local lawyer chapter. When I started doing Second Amendment cases, I switched into a new role at the San Francisco City Attorney's Office and inherited some nascent gun cases, and this was in, I guess it was 2011, and we didn't have a standard of review at that point. It was, the cases I had a concealed carry challenge and actually 2 concealed carry challenges, and we didn't know what was going to be the test for evaluating whether or not these laws were constitutional. So we were really writing from a blank slate and writing from scratch. And at that time, we all sort of expected the Supreme Court maybe to step in again, maybe to clarify some of the questions that lower courts have been grappling with. And since then, a lot has happened. And so my big picture overview is that Heller, as Adam says, left open as many questions as it answered, I think. It was both an incredibly broad decision in the way it sort of pronounced that this District of Columbia restriction on the possession of guns in the home handguns in the home was categorically invalid under any standard of review. Very, very broad language, very robust language, and yet it also didn't answer questions like, what is the standard of review for evaluating a gun law? Does the Second Amendment even apply outside the home? It had this very mysterious list of what it called presumptively lawful regulations in a footnote. And, courts spent a lot of time trying to figure out what this list meant and how could you construct a coherent rule that would justify all the restrictions on this list. For instance, Heller said sensitive places are in its presumptively lawful list. The prohibition on guns in places like courthouses, that's okay, and the prohibition on gun possession by felons, that's okay. And so courts were sort of working backwards, trying to figure out what is the rule that justifies this list, and we still don't have a very good answer to that. So very broad rule, but a lot of questions that remained. And so then what happened is it was really left to the lower courts to try to figure out what it meant. And so there are sort of 4 areas I just want to describe for you very briefly what the state of the law is, because I think these have really been the big questions that the courts have grappled with. The first one is carrying guns outside the home. Heller was, of course, evaluated a prohibition on guns in the home and didn't have applicability. That the D.C. Circuit law or the District of Columbia law that was challenged didn't apply. The focus was on the right to possess, keep and bear arms in the home for self-defense purposes. And so a huge question has been, what about prohibitions on carrying in public? And it's been sort of a rocky road, at least in the Ninth Circuit. We had initially, in the Peruta case, a very broad panel ruling by the Ninth Circuit that said that prohibiting the ability to carry outside the home in some lawful way, whether openly or concealed, was categorically a destruction of the Second Amendment right, and so struck it down, sort of adopting this Heller categorical framework. We're just not even going to bother with standard of scrutiny and just strike it down. And then the Ninth Circuit took that en banc and reversed it yesterday. And the opinion for the en banc court by Judge Fletcher said that it took a very deep look into the history, going back all the way to, I think the earliest site might have been the 1200s in England. And so a very deep dive, and said that there's whatever right there is to carry guns in public, there's no right to carry them concealed, and that's all that we're looking at here today. And so it upheld this California regime that gives local officials the discretion to decide who gets a concealed carry permit. And that result has been consistent in other circuits as well. The Second Circuit, the Third Circuit, and the Fourth Circuit have all decided carry cases, and some of them have focused. In some of them, they focus more broadly on the public carrying issue rather than just concealed carry. So there are distinctions among these cases, but I don't want to go too deep into the details. And those cases actually in other circuits have been decided under basically a sort of heightened scrutiny, intermediate scrutiny type framework, where the courts have found that there's a good enough reason for the government to be able to impose this restriction. The one exception for right now, there's the District of Columbia's regulation. Its discretionary permitting regime has been enjoined by a district court, and so that's likely, I think the briefing right now is an emergency stay pending an appeal. I'm sure others are involved in this and can speak more to that. But mostly that's been a consistent result, that governments have the ability to restrict the carrying of firearms in public. Another hot area of litigation has been prohibitions on the types of arms that can be restricted. And litigation in this area has focused on prohibitions on large capacity magazines that carry more than 10 rounds of ammunition typically. And those too have been broadly upheld. The other type of arms that's been the subject of this litigation is assault weapons. Sort of certain kinds of semi-automatic weapons that have features that make them sort of military style, like a thing to keep it from getting too hot so that you can shoot a lot of rounds at the same time. And those also have been upheld, typically under intermediate scrutiny, and courts have looked at what's the justification, what is the evidence that restricting these kinds of weapons, these kinds of magazines, promotes public safety. And in the Fourth Circuit, there was a decision striking down one of these prohibitions, but that was taken en banc and re-argued, and we're waiting for a decision there. They've been upheld in the Ninth Circuit. They've been upheld in the Second Circuit. There was a district court decision upholding them in the Tenth Circuit after a trial. The Tenth Circuit vacated on the basis of standing, so that issue is still pending. But those two have also been largely upheld. The other kind of litigation that is sort of has I think is going to be a focus of litigation in the future is issues about the commercial sale of firearms. So there are a lot of very complicated federal restrictions on who can sell firearms, how they can be transferred across state lines. States also have a variety of commercial sale restrictions. California, for instance, has a 10-day waiting period. Allows you to buy a handgun only once every 30 days, for instance. And those I think are, there are a lot of sort of complicated restrictions, and they haven't really sort of percolated up to the circuit level yet, but I think we can expect that to be a focus more and more. The one case that I think is particularly important that I'm watching is a case challenging California's roster of permissible handguns. California sort of has a list of safe handguns that they allow to be sold in the state, and the plaintiffs in a case that's coming up right now have challenged in particular some of the safety features that California requires, including micro-stamping, which is a way that bullets get sort of uniquely identified as they're shot, and as a law enforcement technology, it has evidentiary use in tracing gun crime, and sort of is useful for police, and that's been challenged. And that was upheld at the district court and is now on appeal at the Ninth Circuit. So I think we're going to see more of those, and I think those are actually very, very important. Heller said that restrictions on the commercial sale of arms or laws concerning the commercial sale of arms are presumptively lawful, or it listed those in its sort of list of things that are okay. But of course, there's a lot that encompasses the notion of commercial sale. So the breadth of that and how those are going to be tested, I think, is going to be a very interesting area of litigation. And then the last thing I want to highlight is that we now know the circuits have very consistently ruled that the prohibition on felons from ever possessing a gun is lawful, and also some violent misdemeanors, that those cases are largely uniform. But what's percolating now are as-applied challenges. People with a very old felony conviction who have not been able to get their rights to possess fully restored, but claim that they are safe. And so while these are as-applied challenges, it's an open question, sort of, whether there's a Second Amendment limit on how long someone can be prohibited or under what circumstances someone can be completely prohibited from possessing a firearm. And the other thing that's notable about the Second Amendment since Heller has been the Supreme Court's sort of stunning silence on the Second Amendment and on all of these questions that the circuits have grappled with. The Supreme Court issued Heller, then it issued McDonald, which said that this right applies to the states, is incorporated against the states. And then it has been silent except for a per curiam opinion in evaluating a Massachusetts decision saying that approving a law saying you can't have stun guns, and the Supreme Court just sort of said this is inconsistent. Here are some ways that your decision was inconsistent with Heller. Go back and think about it some more. It was 2 pages, so no real guidance there. And then we've had a couple of dissents from denial of cert, authored by Justice Thomas in a safe storage case and a case prohibiting certain kinds of weapons, the assault weapons that I was talking about. And he was joined by Justice Scalia in both of these opinions, saying, what are we doing? We're treating the Second Amendment like a second-class right because we're not taking it seriously. And in Jackson, at least, the safe storage case, he said, the court is not taking these cases because there's no split in the circuits, but this is so important we need to step in anyway. So that sort of gives you, it's we don't get to see behind the veil there. What does that mean? Why are there only 2 votes there? It takes 4 to grant cert. We have 5 conservatives at the court. Why are they not taking these cases? So who in the Heller 5 did not want to take these cases, I think is a really interesting question. And what's going to happen now that there are only 4 members of the Heller 5 still on the court is, of course, another interesting question that I hope we'll talk about. But that's enough of a 30,000-foot overview from me.
Thanks, Christine. And I would just suggest to the panelists, jump in as, don't interrupt each other, but jump in as each other are talking and react. Alan, I'd like to ask you to sort of respond to some of what Christine has laid out for us. That's a broad series of issues that are being litigated, and you've been litigating these issues longer than anybody else in the country, I think. So I'd like to get your thoughts on sort of the landscape that she laid out, but also your thoughts on how you think the lower courts are approaching the Second Amendment generally, and whether that is sort of consistent with the way they approach other constitutional protections.
Sure. Well, thank you, and I think that was a great overview of what the issues are and where we are in the litigation. The problem that I'd like to present with you here is not my effort to convince everybody in this room that Heller was correctly decided and we should all go out and buy and carry guns. It's probably a tall order for this crowd. But rather, I think that all of us here should be concerned that courts, once they are told that a constitutional right exists at a fundamental level, that certain basic rules are going to apply. My concern is beyond simply securing a meaningful Second Amendment. My concern is, what are we going to see in this country if we're going to determine that some rights have second or even third class status? It's perfectly valid for us to debate which rights are secured by the Constitution, what the scope of those rights are. If you want to have a debate about the correctness or incorrectness of Heller or Roe or Obergefell, that's fine. Those are all valid debates to have, and we can disagree about how those cases should turn out. But once a right is found to exist, then it must mean something. We don't have a hierarchy of fundamental rights where some rights are less important than others, and courts try to weasel out of protecting certain rights simply because they are themselves uncomfortable with the right. If there's a right at the constitutional level, it means that the people have ratified into our basic law a certain provision that says people have some form of autonomy, some kind of immunity from government action in a certain sphere that courts are bound to respect, whether they like it or not, even if they think it's a bad idea to do so. And so we expect to see certain consistent principles apply, and I don't think that we've seen them applied in the Second Amendment area. Now, this is not a new argument that I've made, and it's not an argument that's always made by people from the pro-Heller side of the spectrum. There are 2 interesting law review articles written by people who I suspect are probably not gun enthusiasts. First, we had an opinion, a law review article by Alan Rostrom, who used to be with the Brady Center, who published an interesting article speaking of Justice Breyer's triumph in the Second Amendment battle. And the thesis of this article, and I think it's correct, is that lower courts are treating Justice Breyer's dissent as the controlling opinion in Heller. That is, they are going into Justice Breyer's mode of proposed intermediate scrutiny analysis and applying that, even though the majority opinion in Heller was quite forthright about rejecting what was, of course, the argument of the dissent. More recently, we've had an article by one of Adam's colleagues here, Richard Ray at UCLA, an article about narrowing from below. What do we do when the Supreme Court issues a wrong opinion, and how do we resist that? And this article reviews a variety of opinions that have been narrowed from below. The article argues that this is a good thing. And with respect to Heller, Professor A states that even if lower courts haven't adhered to the best reading of Heller, what they've done is reasonable enough, and we should celebrate that. I would submit to you that this is a dangerous road for us to go on. Imagine if Justice Scalia were the dissenter in Heller, Justice Breyer had the majority opinion, and yet courts were striking down gun laws left and right because, well, Justice Scalia's dissent was somewhat more compelling. I think we would all start to wonder about whether or not the Supreme Court is truly supreme and what this means for the stability of our law, generally speaking. Beyond that, I think we've seen, to dig into the details, some very unusual standing doctrines applied in Second Amendment cases that you would not see applied when other rights go to court. We've seen a very unusual approach to prior restraint that's not what we've seen previously with various fundamental rights. The use of history has been novel and interesting, to say the least. I'd like to get into that. I'm sure Deepak and I would have some things to say. We've had different rules for how to read complaints. Most of us here have taken civil procedure. If you're a lawyer, you know that Rule 8 tells you how to read a complaint and how you analyze the claims that are being made by the plaintiffs. Second Amendment seems to have a different version of this. We have a different understanding of means and scrutiny. What does it mean to apply intermediate scrutiny? Even if you believe intermediate scrutiny is the correct standard in a case, usually the government bears the burden of substantiating the fit, the appropriateness of the fit, whether or not its law actually serves and advances in an appropriate way the valid regulatory interest without infringing too much on whatever right is at stake. Second Amendment seems to have a very different way of seeing that. And of course, with respect to corollary rights also, we're seeing very different doctrines develop. It's obvious that once you have a right to do something, there are going to be certain corollary rights that are sort of unavoidable that are inherent in that right. For example, in Richmond newspapers, we had a holding from the Supreme Court that the First Amendment gives people the right to speak about legal proceedings, so you have the right to attend those. Courts have to remain open. You have a right under Supreme Court precedent to engage in family planning, to have a contraceptive pill or an abortion if you would like to do that. And so certain corollary rights exist. You have the right to buy and sell contraceptives. Do you have a right to buy and sell guns? We've seen arguments now repeatedly by governments that say, well, it says keep and bear. It doesn't say acquire or make. So you have the right to keep this thing, but you don't have the right to actually go ahead and produce it or acquire it from another person. Surely that can't be right. And there's been an effort to stretch this Heller's list of so-called presumptively lawful regulations, which references the presumptively lawful restrictions on the commercial sale of arms to mean that there's no right to buy or sell guns. Well, that can't be correct. The Third Circuit took care of that in a case called Marzarella. They said if this were true, then you could ban all guns simply by banning all gun sales. And we know that can't possibly be consistent with Heller. Nonetheless, we see this argument coming up again and again and again. One of the cases that Christine referenced in the Ninth Circuit, where I filed a brief for an amicus, Texera versus County of Alameda, you had a zoning dispute. Somebody wanted to put up a gun store. They got a variance. There was a finding by the city that this was a needed use in the community, that this was appropriate and fine. But then came the veto of the neighbors who just simply didn't like guns, and they objected to that. And so the variance was revoked, and now came a lawsuit. And we had to have a Ninth Circuit decision confirming that you have the right to engage in commerce related to a constitutionally protected article. I mean, imagine if somebody said, well, First Amendment says you can read books, you can't buy or sell them. That would seem to be a very strange way of handling that amendment. But nonetheless, we're litigating over that. It seems to be a little bizarre. Prior restraint is also an interesting issue. We've seen this case the other day in the Ninth Circuit that dealt with California's law for licensing the carrying of handguns. And nobody questions the fact, nobody seriously questions the fact, my clients and I don't, that the state can require a license to carry a gun, okay? Not really too controversial. What's controversial is when the standards are the police chief will decide whether you have a good reason to carry the gun. Do you have a good and substantial reason? Do you have a justifiable need? Do you have a good cause? These are all standards that are being attached to the exercise of a fundamental right. Now, typically, what we've heard from the courts, Staub versus City of Baxley, is when you have a freedom guaranteed by the Constitution, you cannot leave it up to the licensing officials' unbridled discretion as to whether or not the person gets to exercise the right. You can impose time, place, and manner restrictions. You can say to somebody, get training, have your eyes examined, run a criminal background check, don't carry in certain places. All those would be fine. But here we're talking about basic access to the right in the first place. Do you deserve to have your right? Well, that's not really something that's up to the sheriff. And in many other areas of the law, we know that unbridled discretion is not going to be approved. Not just in the First Amendment, but also in abortion cases. The Ninth Circuit had a very interesting abortion case not too long ago in Arizona. In a case arising from Arizona, Arizona's legislature decided that new science has determined that a fetus can feel pain at 20 weeks. And so even though the Supreme Court said you have the right to an abortion up until 24 weeks, we're going to say that at 20 weeks you need to show medical necessity in order to obtain an abortion. So, of course, people challenged that. And that became Isaacson v. Horn. And here's what the Ninth Circuit said about that. Allowing a physician to decide if abortion is medically necessary is not the same as allowing a woman to decide whether to carry her own pregnancy to term. Moreover, regulations involving limitations as to the mode and manner of abortion, not preclusion of the choice to terminate a pregnancy altogether. Now, what if we were to apply that to the Second Amendment? It's the woman's choice as to whether or not she wants to carry a gun. We can regulate the manner in which she does that. We can regulate the license in some way, but it's not the sheriff's choice as to whether she has a good enough reason to have the gun, because we know that there is a right to bear arms. Like we know there's a right to have an abortion, or at least the Supreme Court says there is. Yet in the Second Amendment, we don't seem to see that kind of logic prevail. Rather, in the Second Amendment, we seem to have cases that come out and say the following. And this is the approach of the Second, sort of the Third, and the Fourth Circuit, very different than the Ninth Circuit case we saw the other day, which I'll get to in a moment. Usually what the other side does, other side meaning the folks here, is they'll say, look, okay, they'll assume that there's a right to bear arms. And that assumption actually is wise from the perspective of the other side, because that's actually Justice Ginsburg's position. Let's go back to what Justice Ginsburg had to say about the right to bear arms. She said, in describing the meaning of the term bear, she said that to carry a firearm in the context of a federal criminal statute surely means the following, as is a most familiar meaning as the Constitution's Second Amendment indicates: wear, bear, or carry upon the person, or in the clothing, or in a pocket, for the purpose of being armed and ready for offensive or defensive action in a case of conflict with another person. That's Justice Ginsburg. And Justice Scalia said, that sounds great. In Heller, they said, we think that Justice Ginsburg accurately captured the natural meaning of bear arms. Okay? So the Ginsburg-Scalia version of bear arms means you get to carry it, including in a pocket or in your clothing. Sounds like concealment. We'll get to that in a minute. That's the right to bear arms. So the courts typically assume that's the right. They don't want to discuss it too much. They don't want to get into the details. And in the Second Circuit, the Third Circuit, not so much the Third Circuit, the Fourth Circuit, they said, we'll assume the right, but it's a very bad right. It causes social harm. People can be irresponsible. And so because the right has such negative side effects, we're going to say to exercise that right, we're only going to let you do that if you have an especially good reason to do so. That is, we're going to ration the right. We're going to reduce the harm associated with the right by reducing the right to exercise, essentially a rationing scheme for a fundamental right. How in the world is that constitutional? I don't believe that it is. It certainly doesn't sound like something that would fly in other constitutional rights. What's happening here is you're seeing the importation of means and scrutiny into the question of whether or not the right exists. It's fine to apply means and scrutiny once you've established the right and you have regulation and you're balancing the two. And in some cases that's appropriate, including in some Second Amendment cases. But what you don't do is you don't say, we're going to balance society's interests and the individual interest in determining whether or not the right exists in the first place. And so you're seeing means and scrutiny in these Kerry cases essentially being used as a legislative matter to overturn the constitutional amendment. Now the Ninth Circuit, because we quoted Isaacson v. Horn to them, perhaps they had a little bit more shame and they didn't want to go through that process. They did something else entirely. In the Ninth Circuit case the other day, they said, well, you don't have the right to carry a concealed gun, and so we're not going to let you have a permit to carry a concealed handgun. Well, that's great, but that wasn't what the case was about. The plaintiffs, I represented plaintiffs in the companion case, Richards versus Prieto, full disclosure. I didn't represent the Peruta plaintiffs. But the plaintiffs in both cases said, look, all we're asking for is the right to carry a gun. We're not asking for the right to carry in a particular manner. The state gets to choose how we do it. Heller says you can ban concealed carry, just like you can ban open carry, because the state can regulate the manner in which guns are carried. No dispute about that. But once the state has made its choice as to how we're supposed to do this, how we can do it, we must be able to access the right. It can't be that you channel the right into a license and then make that license unavailable. So of course we know that there's no right to carry a concealed gun, but it's not really an answer to the litigation which asks, can you restrict our right to carry, not carry concealed, can you restrict our right to carry by making it subject to a permit that's subject to the unbridled discretion of a licensing official by saying, well, you don't have the right to carry in the particular manner the state wants you to carry it. That makes no sense at all. I think it was, well, I'm not running for president, so I'll watch my language, but the dissent said it was myopic. I think that's perhaps generous. But again, this is not the way that we read cases. The use of history is very interesting. I'm not sure if I have another minute.
Well, let's if I may. I mean, I think there's a lot to unpack, including the role of history in these public carry cases. And you know, in addition to the decision that came out yesterday from the Ninth Circuit, these cases, there are actually two companion cases. Well, I guess not companion cases. There are two cases currently before the D.C. Circuit. One of which is Allen's that are essentially litigating, I think,
the same thing.
The same thing. So I think there's a lot to unpack there, and I'd like to hear the panelists' thoughts on that. But I do want to just ask Adam to respond generally. I mean, I think if we stipulated for today's discussion that the lower courts are somehow narrowing Heller, you know, in the ordinary course, the Supreme Court's response to lower courts that are not faithfully implementing its precedent would be to correct the lower courts. And I think this gets to the dynamic that Christine talked about, which is this: even before Justice Scalia's death, in dozens of cases, case after case, the Supreme Court refused to take up these cases. So, you know, something's going on, and we could speculate what it is at the Supreme Court, that they either don't believe that the lower courts are being inconsistent or flouting Heller, or something else is going on. In any event, Adam, I thought Alan laid out an awful lot, and I thought it would be great as a constitutional scholar if you could just respond to that.
Sure, yeah, happy to do so. As has been the case probably for the 6 or 7 years that I've known Alan, I agree and disagree. And I do agree with him that we have seen inconsistency in the lower courts about how to address certain issues. There are a lot of arguments being made in the Second Amendment context that to my mind, don't seem necessarily appropriate arguments to be made in particular cases. And so there is some inconsistency, although I think really the blame goes to the Supreme Court of the United States, not as much the lower courts. The Heller decision just didn't provide the guidance that the lower courts needed to apply the rule and the doctrine that Heller created. Heller was very clear that there's a right to have a handgun in your home for self-defense. On that, there's no doubt. And to the extent that lower courts have found that a law restricts that right, of a law-abiding person to have a handgun in the home for self-defense. They've applied strict scrutiny and tended to invalidate those kinds of restrictions. But beyond that, Heller just didn't answer the questions very well. Christine gave us a little sense of the list of presumptively lawful laws, but those were not briefed and argued in that case. And the court, what the court really should have done in Heller is say, here's a standard of review for how you analyze the future questions that are going to arise. And the court didn't, and that's okay for Heller. I mean, I think that if Heller doesn't do that, it's just the first of a beginning of a constitutional doctrine, and is okay for the court to say we're going to allow it to grow and to see how it turns out. But the result of that strategic decision is going to be inconsistency in the lower courts, because basically what the court has done is say, let's let a whole bunch of flowers bloom and let's see which ones we like the best. So I think the Supreme Court really has a lot to blame about for that standard of review. Where I disagree with Alan is that he says the Second Amendment's being treated like a second-class right. And we hear this argument a lot in the gun world, that we should treat the Second Amendment exactly as we treat the First Amendment, or we should treat it as a first-class right, not a second-class right. Well, that has a certain appeal on a basis of logic, but when you start looking at the doctrine, you start having to ask, so what is a first-class right? So what's our example of a first-class right? Well, First Amendment would be an obvious one, right? Maybe the most litigated constitutional amendment out there, well, at least up there in the top three, and certainly one that has caused a ton of scholarship and public interest and analysis. So what do we have when we look at the First Amendment? Well, the First Amendment is not all strict scrutiny, right? The First Amendment has dozens of doctrines: commercial speech, content neutral, viewpoint discriminatory, et cetera, time, place, and manner. In almost all of these, the courts apply intermediate scrutiny. Sometimes that intermediate scrutiny, depending on the doctrine, is a little tougher than in other areas of doctrine where the intermediate scrutiny is a little looser. But it's not clear to me that the Second Amendment is fundamentally different than the First Amendment when we recognize that, as some of you may know if you're from Hastings, Ash Bhagwat, who's a law professor there, wrote a piece called Intermediate Scrutiny, something like this, paraphrasing, the standard that ate the First Amendment, because it's taken over the First Amendment, and most First Amendment doctrines are in intermediate scrutiny. I think part of what Alan's getting at is this idea that we were all taught in law school, that fundamental rights trigger strict scrutiny and should be treated in a certain kind of way. The problem is that that sentence that law professors always teach their students is not true, is not accurate as a matter of descriptive doctrine, that actually fundamental rights there's only a couple of fundamental rights that get strict scrutiny, right? There's some doctrines under the First Amendment, but not others. Even though the others, it's still a fundamental right. Outside of the free speech clause, very little strict scrutiny in the First Amendment. In the religion clauses, very little. There's strict scrutiny only for very intentional forms of discrimination against religion. All other burdens on religious free exercise under the First Amendment get treated a rational basis review. So that's what a fundamental right gets you in the context of religious liberty, maybe one of the most important constitutional rights in American history and tradition, and you get rational basis review. If we look through, so other than the First Amendment, we could look through Fourth Amendment. The Supreme Court's been crystal clear over and over again. The Fourth Amendment does not require strict scrutiny. Fifth Amendment, none of the doctrines of the Fifth Amendment, well, a couple doctrines of the Fifth Amendment require strict scrutiny, but the vast majority of the Fifth Amendment does not require strict scrutiny. No strict scrutiny, Sixth Amendment, Seventh Amendment, Eighth Amendment. I can go on. But the point is that fundamental rights do not trigger strict scrutiny. Actually, fundamental rights trigger a whole range of different kinds of doctrines, often intermediate forms of scrutiny, similar to what we've seen in the gun case. And I think that one of the reasons why we might be easily convinced, oh, well, we shouldn't treat the Second Amendment like a second-class right. I guess that's right. You should treat it like all other rights, which means you consider the importance of the right, and then when it comes to constitutional litigation, you consider the importance and the fit of the governmental interests. And that's the part I think that we have to consider too. Part of the reason why intermediate scrutiny results in laws being upheld in the Second Amendment repeatedly, and possibly even more than in the First Amendment or other areas of intermediate scrutiny. That's an empirical question I don't have the answer to, but I would hypothesize that the Second Amendment intermediate scrutiny tends to lead to laws being upheld more often than in some other areas of intermediate scrutiny at least. But part of the reason is because the governmental interest justifying restrictions on guns is so powerful. It's public safety, it's public, it's reducing access to firearms by criminals and the mentally ill. These things are very powerful governmental interests. And what we know about regular constitutional law is that really strong governmental interests often lead courts to uphold regulation. Now, there's obviously always the fit question, and I think Alan and I would probably agree on a bunch of fit issues that I think the courts haven't really been systematic about how they think about fit in the Second Amendment area. We might disagree about how they ultimately should go about weighing fit questions, but I think we both agree that the court should pay more attention to that fit question. But to think that the Second Amendment is a second-class right, I think it's based on an idea of what a first-class right that just doesn't fit our understanding and reality of constitutional doctrine.
Adam, just as a quick follow-up, whether in terms of the fit or whether in terms of the nature of the government interest, we've talked already today a little bit about the distinction or the open questions about the application of the Second Amendment in public and to issues like carry. I wonder if you have any thoughts on whether you think the government interests are different in some way in terms of possessing or using guns in the home versus in public, and whether the fit assessment should be different in any way when you look at laws dealing with home possession versus public carry.
Well, I think there's no doubt that we should treat the home differently than we treat guns on the street. And that's, again, not treating the Second Amendment to a different right. You have a right to sexual intimacy with an adult consenting partner of your choice. You don't have a right to do it in Lafayette Square. You have a right to view pornography under the First Amendment. You don't have a right to walk around naked on a street and practice pornography. You can't necessarily bring your pornography out into the public and show it to everybody without finding yourself subject of criminal violation. And the reason why is because there's a sense that outside there's a public and there's more dangers to strangers, and certainly in the eyes of many in the gun control community, that is the danger that's posed by guns out on the streets. So I think there is a difference between guns on the home and guns in the street. And I think that really part of the issue, though, is, and something that Alan and I have agreed on in the past, is that I also agree that discretionary permitting in the context of Second Amendment is very problematic because, as a liberal, I think discretionary permitting by the government to do any constitutional right is really problematic. And I think actually the Ninth Circuit shared that view. Judge Fletcher's majority opinion shared that view, which is why the court went out of its way, I think, to say there is no right to carry a weapon concealed, because they recognize, I think, that discretionary issue. I think Alan mentioned that. Whereas the other courts, the other circuit courts have said, well, there is likely a right to carry a gun outside of the home. The Second Amendment does say keep and bear arms, like it does have the bear word in there. You can't really bear a gun in your own home. But the other courts have said there is that right, but then upheld discretionary permitting that really effectively is a ban. Let's face the fact. In Los Angeles, a county of 11 million people, there are less than 600 people with concealed carry permits. That's an effective ban.
Well, let's stick with Judge Fletcher's opinion yesterday a little bit. I think Christine mentioned that this went back to the 1200s or 1300s. Deepak, you have authored a number of briefs for Everytown looking at history, and particularly in the context of public carry. And I wonder if you have some thoughts about the significance of the use of history and whether, I think Judge Fletcher portrayed the analysis that they were going through as really a faithful application of Heller's methodology, such as it is. I wonder if you have some thoughts on the use of history and some of the new research that's come out recently.
Yeah, so I was thinking about the categories that Christine laid out, which were helpful, and actually Adam and Everytown and our firm have developed historical arguments on almost every single one of these categories. Public carry is the main one I think we want to focus on, but also the types of arms, assault weapon bans. We wrote a brief talking about the history supporting California's 10-day waiting period, which was actually supported by the National Rifle Association originally and supported by President Reagan. The microstamping case. The only category that Christine mentioned where we haven't deployed any historical arguments are these as-applied challenges to felon and possession rules. So I come at this as from the perspective of a general litigator who focuses on Supreme Court and appellate litigation. What's our job? Our job is researching stuff and writing stuff, putting it out into the world and hoping that it has some impact. And I think if you look across the range of legal issues, I can't think of another one where it's more worth spending our time doing that kind of activity than this area. It combines, sort of everything that people who love to geek out about this stuff love. It is an area in which you've heard from the other panelists is completely up for grabs, right? The court has announced the existence of a right, but we don't know for sure what the standard of scrutiny is. We don't know the extent to which the right applies. We don't even know if the court is sort of continuing to believe in the right that it's created. And we know that it's sort of the triumph of original public meaning constitutional interpretation, and history is relevant. And so historical arguments that you as law students or as scholars or as litigators develop can actually make a difference to public safety, right? I mean, in a not to over-dramatize this, but a historical argument that you develop might actually save people's lives. And we live in this moment where I think we're all acutely aware that something is deeply wrong with gun violence in America. I mean, I think, if you saw Hillary Clinton's speech last Thursday, she talked about a lot of great things about America that makes America exceptional. But gun violence is the worst thing about American exceptionalism, right? And President Obama has been repeatedly reminding us of this. So before I say a few words about how we have approached the role of history in the litigation, I just want to emphasize how much this moment is an interesting moment to be talking about this. And Christine touched on some of this, right? You have, even before Justice Scalia died, he died on February 13th, you had the coalition kind of fracturing at the court, right? You had these cases where the gun rights advocates thought they had the right vehicle, Christine's case, the Jackson case, the Highland Park case, where Scalia and Thomas alone were dissenting, and dissenting pretty vociferously from the denial of cert. And then there's just this amazing moment that happened. So Scalia died February 13th. There was an oral argument on February 29th, which was one of the first few arguments when the court came back. The black bunting was still there on Scalia's seat. And Justice Thomas broke his silence after a decade. And why does he break his silence? Because the court is considering a case, it's actually a statutory case. The court had declined to grant on the second question presented, which was a Second Amendment question, about whether people who are guilty of misdemeanor domestic violence crimes can be deprived of the ability to possess guns. And Thomas says, he says, what other constitutional rights are like this? Kind of echoing Allen, right? Like this idea that this is somehow a second-class constitutional right. And he says, what other right is there that results in the lifetime ban on possession like this of a gun, which at least as of now is still a constitutional right? That's what Justice Thomas said. And there's an extended colloquy that's pretty interesting between him and the advocate. And then Justice Breyer breaks in. This goes on for pages, sort of takes over this argument. And Breyer says, well, that's a really interesting major question that we don't have before us. What constitutes a reasonable regulation of guns under the Second Amendment, given Heller and the other cases with which I disagreed? So here's this court the court acknowledging right after Scalia has died, they're sort of in shock that Heller is very much up for grabs, and certainly its legacy is up for grabs. What we have done in our litigation is not obviously to question Heller, but instead to kind of take Heller's methodology and deploy it against the expansive arguments for its application that folks like Allen have urged. The timing of this couldn't be better because we just got this opinion yesterday from the en banc Ninth Circuit, which is the first sort of proof of concept that our efforts might have an impact. And so as Christine laid out, it's this case that challenged California's regulation of public carry. And as the case had been briefed, there was not this historical narrative that had been developed by certain legal scholars, notably Patrick Charles and Saul Cornell. And Patrick Charles, by the way, is a part-time historian who works for the Air Force, just to show you that anyone can do this work.
He's an Air Force historian, to be
historian.
clear.
Yeah, I don't mean to denigrate his credentials at all, but yeah.
Sounded like a denigration.
No, I really don't. I mean,
He was just cited.
he's done excellent work in this area.
He
Really
has an
original
undergraduate degree in
original historical research, and it was cited by the en banc court, and a number of historians have drawn on the original work that he's done and developed it further. But what that historical research shows is that there's actually a 7-century long tradition of the regulation of public carry, and as Christine mentioned, the court went back to. They started in 1299. The opinion says, in 1299, Edward I directed the sheriffs of Safford and Shallop to prohibit anyone from going armed within the realm without the king's special license, which sounds a lot like the California law, actually. And then in 1328, a statute was enacted called the Statute of Northampton that has said essentially that. And what we showed, this is the brief we filed in the Ninth Circuit, and the reason it's this big fat thing is that most of it is actually a collection of historical statutes, working with every town, and every town has a historical researcher who dug all of this stuff up. We assembled 7 centuries worth of historical statutes. This is the Statute of Northampton. You can't see it, obviously, but it's tiny little Norman French on one side and English on the other. And we thought it'd be helpful to actually find this stuff for the court and give it to them. But it's not just English history, right? The most contested history actually is what happened in America to this Statute of Northampton. There's actually a lot of contested history about was this really enforced? And then we end up arguing about the significance of cases from the 17th century, trial court cases, believe it or not, from the 17th century, and what actually happened in those cases. And then when they came to the United States, it's my firm belief after looking at this stuff that the Statute of Northampton came to the United States, was part of early American law, was indeed enforced. And then there were dozens of municipal ordinances actually across the United States in effect that prohibited carry. And so by the time the 14th Amendment is ratified and the Second Amendment is incorporated to the states, it's clear that these kinds of restrictions on public carry are totally ubiquitous. And Adam Winkler lays this out nicely in his book Gunfight. Even our perception of the Wild West is totally off. It's influenced by popular culture. It turns out that Tombstone, Arizona, and Dodge City, these Wild West towns, they actually had pretty strict gun control regulation. The shootout at the OK Corral was a fight about enforcement of gun control regulation. And so that is just a completely different story than the one we have been told, and it shows you the importance of historical research in this area. It's not an argument. Note, it's not an argument that Heller is wrongly decided. It's not even an argument, really, in my view, about whether Heller extends beyond the home. I don't think that's the right way to frame the question. I think instead, we know that Heller tells us that the scope of the right is defined by history. And so then we have to ask, well, what historical regulation existed so that we know what kind of regulation would be consistent with the historical scope of that right? And Northampton and its descendants show us what that is. So I'm really excited about being able to deploy this history in these briefs and change the way, hopefully, that the courts are deciding these cases. The Peruta case yesterday is the first example of this, really, but I don't think it will be the last. And the District of Columbia's regulation of public carry is now up before the DC Circuit, and we've deployed the same history in that case. In the Peruta case, we sort of dropped a bomb on the litigation. There had been no real discussion of this stuff. And at oral argument, every advocate was asked about it, and it came up in a fresh way. The NRA, of course, now has developed arguments, competing arguments on the history, and so, I think there'll be the DC Circuit will have an even more fulsome presentation of this, and it's my hope that what we'll start to see is that this discussion now, the case law will recognize that there's actually a pro-regulation use of history, and that we can deploy originalism against itself.
I think anytime we're talking about a 700, 800-year-old tradition of history, we could spend the rest of our time, discussing the nuances of all of that. But I do want to move forward more quickly than that, because I do want to save some time for audience questions. But I want to actually, Deepak, pick up on something that you were talking about before you got to Northampton, and that is,
you want to go back to 1200.
Right. And that is the sort of dynamic between Justice Thomas and Justice Breyer at the argument in February. And to talk about the way that the Second Amendment, and this is sort of, I'll throw this out to, let's say lightning round to any and all the panelists that want to respond, but a couple of questions. As soon as Justice Scalia died, speculation, there were 5 votes, now there are only 4. Heller will be overturned. The liberal justices are going to attack the opinion. And indeed, as soon as Merrick Garland was nominated, there was, attacks. I won't characterize them as anything other than attacks against his record on the Second Amendment, saying he was hostile. He would vote to overturn Heller. We, of course, haven't given him a chance to expound on his own views of the Second Amendment at a hearing or anything of that nature. But leaving that aside, I guess 2 questions, and again, any of the panelists jump in. First, is it good, bad, or inevitable that the Second Amendment will play an important role, presumably, in any confirmation hearing for Garland or anyone else? Is it, as Adam, I think you recently wrote, true that guns are the new abortion? So is that going to happen no matter what we would like? And then secondly, but relatedly, assuming that eventually the Senate confirms a replacement for Justice Scalia, nominated by President Obama or somebody else, is it likely that Heller will be overturned? And if not, why not? So anybody, please, jump in.
Well, I'll jump in. I think Heller's not likely to be overturned. It's always possible. Who knows what's going to happen? But I think it's not likely that Heller's going to be overturned. I think it's much more likely that if there's a liberal appointed to that Scalia's seat, that what we're likely to see is the Second Amendment will not be expanded much, and that what we're seeing at the lower courts would likely become the law of the land, a kind of intermediate scrutiny where most gun laws are upheld. It might make I think to the extent it makes a big difference, I think one of the few areas that makes a big difference is in this question of carrying a gun in public. The court, even with Scalia, didn't seem very eager to take that issue, frankly. Doesn't seem eager, it was clearly not been eager to take any of the assault weapons ban cases or high-capacity magazine cases or any one of a number of really good cases that have been presented to them on a variety of Second Amendment issues. So I think it's likely that they will not. I think one of the lessons of last year's same-sex marriage case is that, remember Ruth Bader Ginsburg, before all those lower courts said that based on the Windsor, that the bans on same-sex marriage were unconstitutional? Remember we had this weird year where the Supreme Court wasn't ruling on same-sex marriage, but it said the Defense of Marriage Act was unconstitutional for its discrimination. And what we had is this weird thing happen where just 30 lower courts ruled on same-sex marriage in the next 9 months, and every single one of them until I think one of the last ones ruled that Windsor required same-sex marriage bans to be struck down. And what you saw around that time was Ginsburg came out and made a statement about how I was worried about that Roe versus Wade went too fast. And the signal was kind of like, hey, the justices are aware of this worry that there could be a backlash from the same-sex marriage decision. Now, I think what we saw is that there's been a little bit of a backlash, and maybe more than just a little bit, but it certainly hasn't been the kind of backlash that some people predicted or that people associate with Roe versus Wade, rightly or wrongly. But I think it does show that the justices are aware of the possibility that there is a Supreme Court decision that goes contrary to widely held and passionately felt beliefs could cause a backlash. And I think the justices are likely to see that overturning Heller would lead to a constitutional amendment mandating strict scrutiny for gun rights, very, very quickly. And I think realistically that amendment could get passed. It's not one of those constitutional amendments that could never happen, like, for instance, a flag burning amendment or something like that. So I think Heller's not likely to be overturned, just probably if there's a liberal justice, it will not be expanded.
So I largely agree with what Adam said. I mean, on the first question that you asked about, is it a good thing to have a conversation about the Second Amendment? I think yes. I think that conversation should be animated by facts, though. And in the case of Judge Garland, he actually hasn't issued any opinions on the Second Amendment. And it shows you how charged this issue is, that he's being attacked for his views and decisions on on an issue that he's written nothing about. The only thing they have is his vote on an en banc petition.
Yeah, to rehear Parker.
Right, which is a pretty thin read.
Well, I don't know if it's that thin. I mean, usually judges don't vote to rehear things en banc because they just feel like hearing an en banc case.
Well, it could be just his views on the importance of the issue. Right?
He could have concurred or dissented from the denial of en banc if he had views to express. But and look, Justice Sotomayor was asked at her hearing how she felt about Heller, and of course she said yes, she understood this was a right, and of course then at McDonald she said I'd get rid of it tomorrow if I could. So the value of hearings might be limited here. My prediction is, you want my prediction? I think it'll be overruled. I think it'll be overruled in fairly short order, and I think it'll happen because the level of hostility and resistance is so massive and so high. I mean, it's already been abrogated into nothingness in many of the courts. I mean, we're having basic issues with getting into court. Some of the standing doctrines we didn't get to talk about that have developed around the Second Amendment are not anything that you would recognize, let's just say, in any other area of the law. We're seeing intermediate scrutiny being applied not to balance the right against the governmental regulatory interest. We're seeing it as an invitation to relitigate whether or not the right itself is a good idea. And we're seeing that even in the categorical cases. For example, Heller, we all know Heller involved the handgun ban, right? So Heller had to address whether or not, okay, you have the Second Amendment right to have arms. Is the handgun a protected arm? Is this the type of arm whose possession is protected? And the court said yes. And that was the end of the case. Well, what we're seeing in the categorical cases, and actually I've not had too many of these, where there's a ban on some type of gun, a so-called assault weapon or a so-called large magazine, is courts will say, because the evidence is overwhelming, these are arms of the kind in common use by American people. The AR-15 is the most popular rifle in America. They're actually not used in crime all that much. If you want to talk about what's used in crime, that's the handgun, not the large rifle, scary as it might be. But even though we acknowledge that this is within the Second Amendment, now we're going to go to step 2 and balance your right to have this against whatever the regulatory interest is in banning these guns. Heller had no step 2. Heller ended once they figured out that this thing that was before them was protected by the Second Amendment. So we're seeing courts blow by Heller using scrutiny to get at the substance of the right, not just the how you balance the right itself. I'm not that concerned with strict scrutiny. I'm not one of those lawyers who comes in and says it all depends on the level of scrutiny that we get, because even under intermediate scrutiny, the government should have the burden of proof, and there's no deference to the legislative decision that, of course, their law is constitutional. I mean, what legislator would say, I was wrong in assessing the validity of this particular law? It's judges in America who decide whether or not something is constitutional or not, whether or not the fit is appropriate to the right. But we're not seeing that already, given the hostility that we're seeing. I could go on and on and on. I don't really have much hope that it will last, but I think everybody here should be very concerned about that, because if and when, it's probably more when, Heller is overruled, look out. I mean, people here would mostly describe themselves as progressive, and inherent in the concept of progress is this vision that you're inexorably moving forward towards whatever utopian vision of your ultimate policy preferences, right? And so, always progress, never a step back. Well, that's great if you never lose another election. That's great if you're never going to have a judge confirmed who might disagree with your constitutional vision. But once you take the brakes off of stare decisis and everything is up for grabs the minute we can count to 5, then I think people in this room really need to worry about some of their favorite constitutional decisions and whether those rights, which are not universally accepted in America, are going to remain on the books either.
So I want to jump in just because I have to disagree with a lot of what you've just said.
Great.
You knew it had to happen. I don't think that lower courts are blowing by and disagreeing with Heller. Heller is a very narrow opinion. And I think what Heller, I don't think it's going to be overruled. I think that the court, for one thing, the right to own a gun is very popular. And for another, the scope of the right, as the Supreme Court laid it out in Heller, is pretty narrow. It's a right to keep and bear arms in the home for purposes of self-defense. There's enough language in Heller to suggest that there's at least some application outside the home, such that certain kinds of restrictions are likely, I think, to be invalidated later on. But I think it doesn't go much beyond that. I mean, Heller said that it is not a right to keep and bear any arm in any manner, and I know I'm paraphrasing and Alan hasn't memorized, but Heller is just a pretty narrow opinion, and I think what the court was doing in Heller, I mean, I think what there was a majority for, there were 5 justices for policing this outlier jurisdiction. I mean, the District of Columbia and Chicago were the only 2 jurisdictions that completely banned possession of guns in the home. The only 2 out of thousands and thousands of local jurisdictions in the United States, and the Heller court struck down that extreme outlier of a law. And I don't think that's, you know, that doesn't reach very far. And what the other courts have been doing really is upholding laws that are pretty common. I mean, there's a big sort of cultural divide in our country, I think, about guns that maps a lot of our other disagreements, but it doesn't seem inappropriate to me for, you know, for a city to decide that it's very densely populated and needs different restrictions than a more rural community. I mean, that doesn't seem outrageous to me, and you know, this notion that there ought to be some political control over how far we insert guns into public life by sort of this awareness that they could be everywhere, that the person sitting next to you on the bus could be armed. The idea that we would want to politically control that rather than have it taken out of our hands, it doesn't seem like that much of a stretch to me. And I think that the Supreme Court, I think whatever Supreme Court we get, after we get a new president, after we get a new justice, or maybe if Judge Garland is elevated, I think even a left-leaning court is going to live with Heller.
So I think most of our discussion so far has been talking about the Second Amendment and the Constitution, the way lawyers tend to think about it, as, you know, sort of a set of rules that courts enforce, and, you know, what laws will be struck down or upheld. But especially when it comes to the Second Amendment and Heller, I think it also is a kind of symbol. And I think in a lot of ways, Heller actually has more sort of significance as a symbol. There's something that happens when the Supreme Court says there is this constitutional right, and it exists, that legitimizes a certain set of beliefs about the issue. And so I think, you know, even though, you know, Alan has been very frustrated in his litigation in getting courts to try to operationalize some more expansive conception of Heller, in the political sphere, Heller stands for much more than what it does as, you know, just a set of rules that are operationalized in the court. And I think that, you know, the progressives, the liberals, who are on the court now or who will be on the court in the future will recognize that. And you know, there's sort of a similar kind of conversation about abortion, right? I think that folks who are opponents of Roe v. Wade recognize that they can deprive it of content without necessarily overruling it and provoking the kind of backlash that Adam was describing. And so that's why I think, you know, why would we want to sort of immediately overturn Heller? If the real debate is, what does Heller stand for? If it's a very narrow decision that Christine has described, then it doesn't need to be overturned and provoke that kind of backlash. And look at what's happened. Justice Scalia, as I said, he died February 13th. The Caetano decision came out March 21st. So it took the Supreme Court less than 1 month after the death of Justice Scalia to reaffirm Heller. I think that shows us that, you know, Heller is not about to be overturned. Nobody on the court is chomping at the bit to overturn it. Otherwise, why would they have signed on to this per curiam opinion that upholds Heller and applies it to Massachusetts' stun gun law?
Well, because there's no way, even Caetano was 12 steps too far. under Heller, and it was a very, as Justice Alito said in his concurrence, a very grudging opinion that didn't actually even strike down the law. They just sent it back.
Sure.
And I can predict to you what will happen if Massachusetts chooses to fight. I have no idea what they're doing in that case. I haven't followed it. Maybe you know, but they'll probably just say, well, intermediate scrutiny, everything is okay. Stun guns are dangerous. This person was outside their home. Blah blah blah, and that'll be the end of it. I don't think that they're necessarily going to get rid of even that one law. But the fact is that we are seeing this right treated very differently in all kinds of ways than other rights. And if you're okay with that, then look out. And I don't think you're going to like how that spins out in the future. It's a very bad precedent.
I think it's always good to get to a point of robust disagreement on a panel like this, and I think
And then turn it over for questions.
I think we've gotten there. We have Heller has been abrogated into nothingness, I think was the phrase, Alan. On counterpoint, it has not been abrogated into nothingness. So it will be overturned. It won't. So we'll see how this plays out. But we do, and unfortunately I only have a few minutes left, but we do have some time left for audience questions. So if there are any questions, please, I think if you'd step up to the microphone there to ensure that it will be recorded, that'd be great. And please.
Thank you. This is on. I was hoping to ask about a recent DC Circuit argument that was made in the United States versus Rodney Class case, which, I mean, maybe you're familiar with, maybe you're not. But it was a two-part case, the first part dealing with a pleading issue, but the second part was a Second Amendment challenge to the right to bear arms on Capitol grounds. And I was wondering if you were foreseeing further restrictions, further challenges to restrictions of sensitive areas under the Second Amendment.
It was a criminal prosecution?
It was a criminal prosecution of an individual who had guns in his car on the Capitol parking lot. And it was argued in the DC Circuit maybe 2 weeks ago, so I was curious.
I mean, no advocate would have picked that fact pattern to bring a test.
No advocate did. I'll tell you what happened.
Dumb case.
No advocate did. Mr. Class is a sovereign citizen, French flag type guy, who argued with his public defender and was allowed to argue, I think, in pro se. The court appointed another lawyer to sort of as an amicus to argue on his behalf. I don't think that you have a right to carry guns on the Capitol grounds. It's not, and nobody disputes that sensitive places are, can be made into gun-free zones. The question
Mr. Class may
Mr.
actually
Class
dispute
may.
that.
I don't see that going anywhere. But the question is, what is a sensitive place? How do we define that? Interestingly, in Moore v. Madigan, this was a case that I handled where Illinois' total ban on the carrying of guns was struck down. And so there's one massive, great progress. You're all progressive. That was progress. Illinois is now a shall issue state. The state sought rehearing en banc, and there was an interesting dissent from the denial of en banc, which tried to explore what a sensitive place might be, and it listed areas in or around parks, buildings, trees, people, stuff. I mean, it's a list that goes on and on and on. I think the word forests was there. No. So if a sensitive place is an area even around a forest, you can imagine. I mean, this is trying to cut the use the exceptions to swallow the rule. In the Teixeira case, which involved a zoning challenge to where gun stores can be located, the county was trying to justify keeping gun stores away from residential areas. Residential areas are sensitive places, and the Ninth Circuit said, well, wait a minute, you can have a gun in your house, right? So you can have guns in a residential area, so how come having a gun store near a residential area be infringing on a sensitive place? We need more guidance on sensitive places. I don't think it's an issue being litigated very heavily right now, and I think probably not worth litigating too much.
Don't you think that the Wren and Grace cases, which are now before the DC Circuit about public carry in the district, sort of implicate this question? Because in a way, the entire district is a kind of sensitive place. I mean, it's the seat of our national government. The question is whether people have a constitutional right to carry in this place full of members of Congress and foreign ambassadors, and and we want it to be a place where people can sort of freely go about, and all of these people who could be targets of various kind of political violence, and so I think in some ways that is implicated.
Well, I'll tell you, I mean, there are targets in this city. It's the 500,000 people who live here who are targets every day of violent crime, and they should have a way of defending themselves. I mean, I appreciate that there are important people, and we should do our best to safeguard them. But as President Obama's first press secretary said himself, the laws don't change when the president comes to town. And even they took a position that just because the president happens to be going somewhere doesn't mean that that place loses the Second Amendment. Rather, you have the Secret Service, they secure the area, they impose certain restrictions, and that's all fine and appropriate. But you can't say that the entire capital of the United States, you know, a large city home to 500,000 people or more with more visitors, is entirely a place that's free of a fundamental constitutional right, especially one that's so urgently needed by people. I mean, we had the same arguments in Parker and Heller. Oh, D.C. is a sensitive place. There are important people here. We can't have handguns. And the D.C. Circuit said the Bill of Rights applies in Washington, D.C. That's been the law forever. And the Supreme Court didn't even look at the argument when it went up.
I don't think we have enough time to fully resolve this question this morning, or this afternoon, I guess now. Fortunately, both of you have thousands of words to the D.C. Circuit in the next couple of weeks and months to try and resolve this. So let's open it up to another question, sir.
In 1968, we had a major piece of gun legislation passed because of 3 assassinations. And I plead failure of memory, was there a constitutional discussion there? Was there a constitutional problem? Did Congress look at it? Was it ever tested?
So I've looked a little bit about the debate. There was, about the legislative history, there were certainly those who opposed the Gun Control Act of 1968, which banned the importation of certain kinds of firearms, so-called Saturday night specials, provided increased licensing, clarified some of the other rules on felons in possession and stuff like that. And there were people who disagreed with the law and thought that, and made an argument that it was unconstitutional under the Second Amendment. What was interesting about that, and what was unique about that, was that, you know, for the longest time in America, the NRA did not focus on the Second Amendment when talking about gun rights. If you go back and look through the NRA has a signature publication they give out to all their members, the American Rifleman, and you can go back in your local library, like I did, and get the big books, all the bound volumes together for decades, from the 30s, 40s, and 50s, and you go through those volumes and you just peruse them. If you go through that volume today, it says the Second Amendment on every other page. You go through in the 1930s, can't find a single mention. I'm not going to say there's not a single mention somewhere in 10 years of documents. I didn't read every page, but looking through it, you just don't see discussions of the Second Amendment. So part of that story is that the NRA believed in gun rights, and in the 1930s, the president of the NRA testified about the 1930, the National Firearms Act in the 1930s, and the NRA president said at the time that, in answer to a question about whether the Second Amendment imposes any limits on federal gun control, he said, "I've never given that question any study." And elsewhere, that same person, Carl Frederick, wrote that protection for guns is not from the Second Amendment, but from good policy. So part of the story is that what was happening by 1968 is a shift was happening in the NRA. And the NRA was at the beginning of a transformation that was really confirmed in 1977 when they had a revolt of the membership. Literally, the NRA was changed overnight. And sort of just the birth of what became the modern gun rights movement really was found in that 1968, in the opposition to the 1968 Gun Control Act.
Is that a good argument that the interpretation of the Second Amendment that in Heller is not really historically based?
I don't think so. That's not what I was. My point was really about the NRA, not necessarily about the larger question about gun rights in America. I think gun rights in America have been respected by legislatures by and large for a long, long time. And doing a sincere history and tradition analysis under the Due Process Clause or under the Second Amendment, I think leads to the conclusion that there is an individual right to have a firearm for personal protection. So historically, I don't think that wasn't my point. It's more about the NRA and how that moment led us to the moment we're in today.
I would just share one thought in terms of the relationship between the Gun Control Act and Heller. You know, the Gun Control Act 1968, with some subsequent modifications, really remains still the sort of backbone of federal gun law in the United States. And I think it's interesting to note that several of these presumptively lawful types of regulations that Heller identified as not violating the Second Amendment sort of really parallel the provisions of the Gun Control Act. So prohibitions on possession by mentally ill or folks convicted of felonies, commercial conditions on the commercial sale. In all of those areas, the 1968 Act really put those into law as again the sort of basic foundation of federal gun law. So I think Heller, rather than calling into question much of, if not all of, the 1968 Act, really said that's the baseline. You know, that clearly doesn't violate the Second Amendment. What we can certainly, folks will disagree about whether that's true or not, but that I think Heller certainly seemed to, whether it was the cost of a fifth vote, we can speculate, seemed to suggest that those provisions were at least presumptively lawful and not unconstitutional.
And that, I mean, that's very useful in the historical analysis in these cases in litigating Heller, because we get to make arguments, even 20th century arguments could be relevant because of the examples that Heller gave. And so, you know, like, for example, we talked about the waiting period cases. That's why we get to say, you know, the NRA supported these laws. These laws have been around for 100 years.
Yeah, the question actually relates, interestingly, to Deepak's work, because what happened is a lot of the research into the Second Amendment's meaning was a reaction to legislation. The fact is that for a lot of our nation's history, we've had gun laws here and there, but it wasn't really a controversial issue in society until the latter part of the 20th century, and so that's what fomented a re-examination of what the Second Amendment might mean. And actually, a great many liberal scholars came in and looked and said, wow, this is what Sandy Levinson called it, the embarrassing Second Amendment. In the 1960s, I believe it was 1965, the ABA gave an award to a gentleman who would later become a Seventh Circuit judge, who wrote an article for their magazine who said it secures an individual right, and sounded a lot like the kind of stuff that we would later say 40 years later. But what we saw was, from the other side, was derisive comments that this is what's called, what Saul Cornell called it, law office history, this idea that lawyers can't do history because they're not professional historians. And there was an interesting exchange between Judge Posner and Judge McConnell a couple of years ago at the Federal Society, where Judge Posner went on and on about how lawyers can't do history, this is inappropriate. He said, you know, our clerks aren't historians, and Judge McConnell said, well, they're not economists either. And that was, and so now it's kind of endearing to me a little bit to see law office history, even Air Force history, being marshaled by the other side. And look, history is valid. You don't need to be a specially trained official historian to read and understand and make historical arguments. So I welcome Deepak's foray into this. I think he's wrong about a lot of what he says, but at least we're talking about the same thing. You know, that's what, no. We're at least what matters here is the text and the history, and we can debate that, but at least we're sort of in the right universe.
I think we've got time for one last question.
Yes, Hillary Clinton, Secretary Clinton, last fall, I believe, was talking about repealing the Protection of Lawful Commerce and Arms Act. And so I would guess maybe it's because I'm arising too well. I don't quite understand what the purpose of the PLCAA is when we don't have similar protections for, say, drug companies, automobile manufacturers, tobacco companies. Even the church itself can be sued for the actions of its clergy. So why do we need a PLCAA to protect gun manufacturers and people who sell guns?
Because you don't want a jury somewhere, 12 random people in some carefully selected jurisdiction, abolishing a constitutional right by imposing catastrophic liability under tort theory that prevents people from exercising a fundamental right. I mean, I suppose we do have protection against suing websites, for example. We have all kinds of other protections built in for industries. I suspect that if tort doctrines developed in such a way that threatened a right that you care about, we'd probably see congressional reaction as well.
So, well, I mean, didn't that happen with, say, Ford in the Pinto case? Yeah.
Well, I don't know that there's a fundamental right to drive a Pinto.
Well, there's a fundamental right to travel within the United States.
But the question is that can you use tort doctrine to essentially declare a constitutional right to be a tort, that is the manufacture of arms, the people have a traditional expectation of being able to maintain. We're not talking about suing people for what's traditionally a defective product, a product that misfires. We don't want guns to explode in people's hands or to jam or to be unreliable, and those tort cases can proceed. You can also still go after people who violate the law, people who are careless in how they sell or distribute their firearms. But when the tort theory is, this is an inherently dangerous product because I disagree with guns in society, then you're empowering a jury to essentially override a constitutional amendment, and that cannot be.
Well, that's a caricature of the statute. I mean, the immunity goes much further than that. And you know, the other area I work a lot on is consumer protection. And it's really amazing that you have this inherently dangerous product that is exempt from the kind of standard consumer protection regulation. I mean, a toaster is more regulated than a dangerous firearm. That is a truly bizarre thing. I thought right, or a mattress, right? So I thought the debate over this statute was really encouraging, and you know, it'd be great to see a repeal.
Well, this is even better than I thought. We've not only disagreed about the Second Amendment, now we're disagreeing about the Protection of Lawful Commerce in Arms Act. So this is truly a great note to end on. I want to thank all of you for taking the time to join us here today. I want to thank all of the panelists.